Welcome to this webinar, which is going to address legal developments and defense strategies arising out of market manipulation. My name is Sasha Wass. I have been a barrister for 39 years and a QC for 20 years, and I have spent much of my career involved in financial crime, both from the prosecution and the defense perspective. By way of introduction to this webinar, a few words. The key function of financial markets is to allow traders and investors to communicate their subjective view of the price of any financial instrument. So if a trader, for example, offers to sell an asset for, say, £100, he is signaling to the market that that asset is worth £100. Now, obviously, hundreds and thousands of traders operate in the market at any given time. And the amalgamation or the aggregate of the pricing opinions, that is to say, my asset is worth £100, of the many of the thousands of traders will allow other buyers and sellers to reach a rough consensus of the market value of the financial instrument in question. So in short, trading information is exchanged and allows potential buyers and sellers to discover the real price of any given asset. However, in order for this system to properly work, investors must have faith in the integrity of the pricing information. They've got to believe that the pricing information they're getting from the signals is genuine. Now, market manipulation has been defined by the US Supreme Court as any act which obstructs the operation of markets indices in real value. So effectively, market manipulation is an activity within the market designed to have an artificial or deceptive effect on the market. And it obviously is detrimental to the market, the integrity of the market, and the confidence that anybody would have in the market. Now, problems arise because all market activity is going to have an effect on the market, however small. And it may be difficult, and often is difficult in real terms, to distinguish lawful trading activity, which may be quite bold, and unlawful manipulation, which is designed with the intention of deceiving other traders. And this grey line between lawful manipulation, unlawful manipulation, and lawful trading can present difficulties to traders or compliance professionals staying on the right side of the law. And this presentation focuses on a type of market manipulation known as spoofing. And in effect, when spoofing, and the contributors will deal with this in much more detail, false orders are placed on the market, often bulk orders, to give an effect or send out a signal that a particular asset is worth more, is going up in value and the like. And then at the last minute, that order is taken away, causing an imbalance in the market and allowing a manipulator of the market to take advantage. Now, spoofing has been a key priority for US law enforcement in recent years, and signals indicate that it's becoming the focus of regulators in the UK and in the EU as well. Now, can I introduce the contributors to this webinar? Firstly, Nate Muskins is a Washington-based lawyer, co-chair of Greenberg Traurig, a co-chair of the Global White Collar Criminal Defense Practice. He represents companies as well as individuals in investigations, prosecutions, regulatory inquiries, and civil proceedings. And he was one of the leaders in the defense team of a case called United States versus Flotron, which was a case that resulted in the first ever acquittal in a criminal spoofing trial. Then we have Barry Vittu, again, co-chair of Greenberg Taurig, White Collar Criminal Defense Practice. And Barry is also head of the London office of the White Collar Defense and Special Investigation Practice. Barry is an expert in defending multinational corporate defendants in investigations and contentious litigation. And he has been brought in by US and UK law enforcement agencies as an advisor, including the Serious Fraud Office, the Financial Conduct Authority, and in the United States, the Department of Justice and the SEC. Dr. Esme Carr is a New York-based economist specializing in financial markets and regulation. He is a recognized authority in financial, accounting, economic, and governance issues, especially those relating to high-frequency trading in futures and equity markets. He's regularly asked to testify on behalf of both law enforcement and defendants in US and in the international courts. Joshua Ray is an English solicitor and a UK qualified lawyer. Josh is head of Rahman Ravelli's US-facing business crime practice group, and he has substantial experience defending those charged with market manipulation offences. Josh is also the co-author of the forthcoming book on white-collar litigation in the US and the UK, which is scheduled to be published by the American Bar. And then finally, but by no means least, we have Neil Williams, a highly experienced defence solicitor at Rahman Ravelli. He's an expert in corporate crime and regulatory investigations who specialises in cross-border, global bribery and corruption cases. He regularly defends executives involved in internal investigations and has recognised expertise in cases involving cross-border tax fraud. Now, I make it plain on behalf of all of our panelists that they are giving their own personal opinions. And although they have been involved in particular market manipulation cases, they are not relying on any information given to them from their current or former clients. They are relying on publicly available information. Now, if anybody has any questions during the course of this presentation, which they would like addressed later, if you go to the bottom of your screen, if you press the cursor, go to the bottom of your screen, you'll see that there are a number of participants, but on the far right, there's a Q&A box. Could you please use the Q&A function rather than the chat function to put your questions forward? So with that introduction, may I start with Neil, please, and to give us the basics. What exactly is spoofing, Neil?
Okay, well, thanks, Sasha, for that introduction. And I think it's right to say that many will be familiar with the concept of spoofing. But perhaps just to summarize, it's a means of manipulating trades for a particular product in financial markets, such as futures, stocks, or other items. Now, under the US Dodd-Frank Act of 2010, it's defined as the illegal practice of bidding or offering with intent to cancel before execution. Now, other jurisdictions have also addressed the practical interpretation of spoofing with slight variation, but essentially they all commonly agree that typical examples will be where genuine orders are placed on one side of the trading book, either to buy or sell, and then multiple corresponding offers are simultaneously placed on the other side of the trade in order to give a false impression either of supply or demand. Now, according to enforcement agency investigative theories, the purpose of this is to try and induce other market participants to believe that there is pressure to either buy or sell, and then depending on whether offers or bids are made. Now, this can trigger price fluctuations as the market interprets the increased pressure on one side of the trades as a shift in balance of the number of investors on a particular side of the market. Now, prices may then accordingly increase where there are more apparent buyers than sellers, or begin a downward trend on the other side if there appears there are more sellers than buyers. Now, once the genuine order mark is reached, with the market either increasing or decreasing, then the multiple false orders are then rapidly withdrawn. Now, the real intention of the trades is then accomplished. However, the market is being falsely manipulated in order to achieve the goal. Now, as we'll hear later, theory can give way to alternative reality, and what may appear to be a provable case can present obstacles on the route to conviction, as the underlying intention behind the trades can sometimes be less easily defined. Now, the speed at which trades take place and the length of time which offers remain on the order book have affected the interpretation of intent by the authorities. And the test for wrongdoing appears to be evolving. The goalposts appear to shift depending on the view of the authorities at a particular time. So it can be difficult to judge what may or may not be construed as wrongful intent. And I think my colleagues will be running through the evolution of prosecutions with reference to case law in due course. So if we look at the spoofing slide as a simplified example of how market manipulation can occur, we can see at point 1, there's a genuine trade bid by trader A, and it's made at a particular price, in this case, $998.80. And then corresponding with this, and in order to try and drive the market down, in point 2, we see falsified or spoof excess offers by trader A at the lowest price currently on the market, which is shown here as $1,000.20. Now, at point 3, alarm bells might be ringing elsewhere, and we see unconnected trader X anticipating that as a result of the market now apparently increasing, the offer market, there is a risk that prices will now begin to follow a downward trend. Therefore, they move to fulfill trader A's bids and to achieve the apparent best price based on what appears to be the emerging market trend. Now, point 4, trader A has accomplished their mission. They've purchased stock for the price they set out. Therefore, they cancel the spoof orders, which were never intended for the market in any event. Now, as I say, this is perhaps in its most simple form, but as we'll hear, it's not always that straightforward. Okay.
Can I ask you, Barry, how is spoofing regulated in the US and in Europe? I think, Barry, your mic is off.
Instant fail. Yeah, so, well, the slide sets out some various pieces of legislation, regulation, which govern it across the EU, US, UK. I think in the US, I think as Neil's just mentioned, there's some specific legislation. UK, it's much more general in terms of the way that they approach it. The financial services, the FCA, through market abuse regulation, probably have the most targeted piece of regulation. But otherwise, you're looking at some quite generic stuff, which does give prosecutors, and Neil's already alluded to this, some difficulties when they are looking to prosecute these things. But the takeaway, I think, from this slide really is that you can see that there's various pieces of different legislation which all say somewhat different things. And importantly, they're all, and this will become apparent a bit later in the presentation, they're in different jurisdictions across all over the place. And given that people trading on these exchanges can be pretty much anywhere in the world, and that will emerge a bit later as well, it could be the case, almost certainly will be the case for many traders, that they will actually be subject to the jurisdiction of more than one place. So you end up with a bit of a patchwork quilt of regulation and obligations that you have to comply with. And if we flick into the next slide, I think, in fact, well, that wasn't the slide that I was expecting, well, the back to front, but nevertheless, you'll see that in addition to having a smorgasbord of regulation and legislation, which is all a bit different, we then see that we've got a smorgasbord of different regulators and law enforcement agencies and civil bodies that also sort of swoop in to enforce all of this stuff. So it's, if I can continue my needlework theme, the patchwork quilt, so sort of we're now moving to a tapestry of enforcement agencies and laws and regulations which govern this space, none of which is hugely helpful to those looking to comply with it. So if we click on switch, I mean, I suppose one thing, I don't know if Nate, you want to talk about the US a little bit, but basically the DOJ, which is the one with the, well, they've both got eagles, haven't they? But the one to the left, they're the criminal enforcement agencies up there. The SFO would be the sort of the closest you could get to it in the UK, with the balance essentially looking at civil enforcement. And Nate, I don't know whether you want to chip in on the US side.
You know, I think the thing to remember about this slide in particular is if you go from bottom right ACER up to the top left DOJ, it almost is it's almost a chart of who can make your life the most miserable, with the DOJ being the top and the NYMEX, for instance, on the bottom being below. You know, the CME group, ICE, NYMEX, none of those people can put you in jail. None of those people can send FBI agents to your house and kick your door down. And none of them can, you know, they can cause you to not be able to pay your mortgage and to disappoint your family and friends. But again, the Department of Justice can make you share a cell with a guy named Bobo. That's the way I view the difference.
Yeah, and I suppose, I mean, and on that, I mean, the FCA can make your life miserable for all sorts of different reasons. So far, they haven't made anyone share their cell with somebody called Bobo, so far as I'm aware. But the important thing, I think, from a UK perspective, is so far, the UK's approach to this has been to sort of go down the civil road, whereas the US, I think, has done it all and quite likes to take on criminal enforcement as well. And I think we'll see a bit later what sort of outcomes that there have been. So, but just moving on to the next slide, which again just highlights the sort of the global nature of all of this, and as does the next slide, if the point wasn't already made. In terms of evolution of prosecutions in the US, Nate, do you want to just give you're probably pretty well versed. You've been in at least one of these cases. So how's the picture shaping up there?
Sorry, I'm following along on the slides myself. Yeah, evolution.
Yeah, sorry, Barry. I think we might have gotten ahead of ourselves there. But
really?
So yeah, sorry. So, but just one final thing on this slide that's currently up. So I think an important thing for the traders out there to remember, in addition to what Barry just walked through in terms of the kind of the overlapping tapestry of the various different regulatory regimes that there are, is that at least in the United States, the DOJ and the SEC and the CFTC all take the position that regardless of where a trader might be physically located in the world while they're trading, as long as their trades are being executed on a U.S. exchange, they're subject to U.S. civil and criminal litigation, or sorry, U.S. criminal and civil enforcement. And actually, interestingly, a big percentage of those criminal spoofing cases that have been brought to date have all involved traders who are located overseas. So there's been a number of individuals based in London who have been charged in the United States. There's been one from Switzerland, a few from Singapore, and then elsewhere in Asia, and at least one from Australia. So it's really important, I think, particularly for retail traders or individuals who are trading at potentially smaller firms around the world who might be trading on some of the larger exchanges in the US, that they really need to keep up to speed with the shifting kind of theories that the U.S. law enforcement has been imposing with respect to spoofing, so that they don't end up in a cell with Bobo, as Nate mentioned. So another thing, just quickly to remember, is that the U.S. obviously has been the epicenter of spoofing regulation to date, and we're slowly seeing the U.K. start to move in that same direction. But then there are a number of other regional regulators in different places in the world that who also already have on the books prohibitions against spoofing, although we haven't yet seen them actually really actively enforce those laws, but they are on the book. So we're just mentioning two here. So one is the Gold and Commodities Exchange in Dubai, which is a major hub for trading in the Middle East, and also for traders in India and elsewhere in Central Asia. And obviously, focus of that exchange are oil and gas futures, which a number of the U.S. enforcement actions against spoofing have targeted. So that will be an interesting exchange to watch to see if spoofing becomes a regulatory target there. And the same thing in the Netherlands. So Euronext, which we'll be talking about a little bit later, is a Europe-wide exchange with regional offices. And the one located in Amsterdam is one of the biggest Euronext divisions. And the Netherlands Authority for Financial Markets has authority for any trading crossing Dutch markets. So again, that's another major hub. It's another place where there's a robust regulatory capacity, and somewhere that I think traders who are trading on a Dutch exchange should really kind of keep watching out for regulatory actions targeting spoofing going forward. And so going back to the U.S., I think what we meant to capture here in this slide is just to explain how spoofing has emerged and how it's been interpreted over time in different ways by U.S. law enforcement and U.S. courts. So as Barry alluded to it earlier, with Dodd-Frank, it was the first time that a law specifically prohibiting spoofing came out, using the actual word spoofing.
Josh, can I ask you
sorry.
just to explain that fully to anybody who hasn't heard of the Dodd-Frank Act of 2010? This was passed, was it, in specific response to the financial crisis of 2008 and 9? Is that right?
That's exactly right. So it was a...
Perhaps you could just explain to people what the effect of the Dodd-Frank Act was in real terms.
Sure. So Dodd-Frank is a massive piece of legislation. I think it was 900 pages covering all sorts of things. And within that legislation, there's a single line that basically amends the Commodities Exchange Act to prohibit trading activity of the nature of spoofing. Now, a big question that's been raised by a number of people since then is, well, what does that really mean? So Dodd-Frank has essentially come to be kind of there's a before Dodd-Frank and after Dodd-Frank era in terms of spoofing enforcement. In the U.S. government takes the position that spoofing has always been illegal, even before Dodd-Frank, and that the specific regulation put into Dodd-Frank was essentially just a reaffirmation of what was already on the books as illegal. But the first criminal spoofing case that actually went to trial was the U.S. versus Kosher case in 2015. And one of the things that is interesting between that case and to today is that we've seen an evolution from algorithmic traders being presented as the defendants in spoofing cases to algorithmic traders being almost exclusively presented as the victims in spoofing cases. So algorithmic traders, just briefly, are traders who use computer programs to execute trades rather than manually entering buy and sell orders. So the Kosher case, the Oystacker case, and the Sorrell case were all involved defendants who were using computer programs to trade at very high speed. Then the Flowtron case, which Nate defended, and he'll talk about a little later, that was the first criminal spoofing trial that involved a manual trader. So someone just sitting at their computer, physically hitting buy and sell. The Thacker case was kind of the next step in the evolution, where Thacker wasn't even a trader at all. He was a computer programmer who was alleged to have helped Sorrell engage in his alleged spoofing conspiracy. And Sorrell testified against Thacker in Thacker's case, and essentially said that the purpose of this computer program that Thacker programmed was to engage in spoofing. Everyone knew it was wrong, etc. Despite that testimony, the jury eventually deadlocked against Thacker. The court declared a mistrial, and DOJ declined to prosecute him. The Leck case was notable because it was the first time that a case went to trial where it wasn't spoofing under the Spoofing Act that was in Dodd-Frank. It was spoofing on the stock market for the first time. So that's kind of the next step in the evolution. And so that went to trial. The SEC reached a verdict in that. Leck was found guilty. We actually talk about the Leck case a little bit a little bit later on. And just briefly, the JP Morgan case was a massive DPA that was announced earlier this year. They agreed to pay $1 billion to the government. And that case is notable, not just because of the dollar value involved there, but also because JP Morgan essentially admitted that their precious metals desk and their treasuries desk had been using spoofing as a open practice, as an extremely widespread practice for a number of years, which then leads us to the U.S. versus Smith. So Smith is notable because the U.S. government, rather than using the anti-spoofing provision that was in Dodd-Frank or the kind of the general anti-fraud provisions that the SEC used in the Leck case, they used the RICO statute. And so RICO is, kind of well known as the law that was used to take down the mafia bosses in the 80s. And it was actually specifically designed to go after organized crime. So now the US government is alleging that the JP Morgan precious metals desk was operating essentially as a racketeering enterprise over a number of years. So it's an extremely aggressive theory. That case is scheduled to go to trial next year. There's a pending motion to dismiss that the defendants have filed that we'll see how the judge deals with that. But it's very interesting to just kind of see how the U.S. government has now chosen to go after these cases.
Josh, can I ask you, we've had a couple of questions since you've been speaking. Would you like me to deal with those now and we can deal with them as we go along, or would you like me to save them till the end?
I think let's do it at the end, if that works. Yeah.
Yeah. So as far as the evolution of these cases, we can see from your slide here, certainly the narrative, but would you say, Josh, that the emphasis has been on different types of spoofing, or has become more complex since the Dodd-Frank inception of all of this?
Yeah, absolutely. Well, because I think one of the main issues with spoofing in general as a kind of a conceptual matter is that if you just look at the Dodd-Frank statute, it's extremely brief. It's just a few lines, and it's extremely vague in terms of what exactly it prohibits. So the text says, basically says, you can't put in an order that you don't intend to trade. Well, what does that mean really in terms of how long an order must be left open for? Because in a lot of these markets, the vast majority of orders that are placed are eventually canceled. So obviously not all of those orders are illegal. So the difficult question is, well, what subset of all orders is actually illegal, and the statute itself gives very little indication. So through these series of cases that have been brought, you know, those of us who are on kind of the defense side of things have kind of been left to react to evolving law enforcement theories where, you know, originally the Kosher case, for example, they used the fact that Kosher's computer program was canceling orders in a matter of milliseconds as evidence that he was engaging in illegal spoofing. Whereas if we move to, say, the Borley case that recently went to trial, I believe that the evidence there showed that their trades were being canceled within, you know, five or so seconds. So obviously, you know, a millisecond to 5 seconds is an enormous range of time. So it's been kind of difficult, I'll say, to kind of follow the evolving law enforcement theories that have been used.
Can I just ask, Josh, for the sake of clarity, what part, if any, does the requirement of dishonesty play in the American system?
Well, thankfully, the answer is it depends. It depends on what theory the government has chosen to pursue against you. So if they proceed under the Dodd-Frank statute, it doesn't matter at all, technically. Exactly. That doesn't matter what, if you're meaning to defraud really anyone, all that matters is that you're putting out orders that you don't intend to trade. Conversely, if they proceed against you under a wire fraud theory, like they did in the Borley case, then they do have to prove an intent to defraud. But they've been inconsistent. And as Nate can mention too, I mean, in Flowtron, I believe it was only a conspiracy charge. So I don't think they had to prove an exact, you know, intent that anyone actually was defrauded or there was some sort of deception. All that the government needed to prove was that they intended to commit spoofing, which again doesn't actually involve an intention to deceive.
Okay, can I then turn to Barry, please? If you turn your mic on, Barry. What have been the major spoofing cases in the UK?
Okay, well, again, the slide sort of sets them out. Swift Trade was the first. That ultimately resulted in an 8 million fine. They tried to appeal that, but they lost. The Kosher, so those paying attention would have spotted that Kosher appears here. And for me, it's probably one of the most interesting ones on this list, and also on the slide that preceded this one on the evolution of US. And the reason that that's sort of interesting to me is that we've already talked a little bit about the global nature of this. Joss has flagged that, you know, from the US perspective, it's what exchanges you're trading on that count, which is basically going to be the FCA position as well. And here, the evolution of this particular case was that Mr. Kosher was subject to UK enforcement by the FCA. Then, he thought perhaps his troubles may have been over at that point, but they were really only just beginning. He then gets picked on by the CFTC in the US, which brings a civil suit against him. And then finally, he is indicted by the DOJ, where he does actually get to meet Bobo for 3 years. So this is, to me, this is an interesting one because it just goes to show that the enforcement is this tapestry of rules and regulations in various different jurisdictions. I agree with Nate that there's a sliding scale of those that can make your life more miserable, which is sort of evidently illustrated in the Kosher case. But also it just goes to sort of underscore the point that if somehow someone is unfortunate enough to be the target of scrutiny from some of these agencies, you really do need to have a joined up approach to have sort of the least bad outcome or the best outcome that you can get.
Well, I was going to ask you just on that subject, is there a concept of double jeopardy that protects anybody from being effectively hounded by
Well, the Kosha one is particularly interesting in that regard, because Kosha, who as much as his business model did leave something to be desired for his business, he did have some of the absolute worst luck in terms of timing of anyone ever to live, because he had this product, and the evidence that really got him at trial was the fact that he'd hired people to create computer programs that spoofed. So when the architects of the computer programs were on the stand, they said, yes, Mr. Kosha told me to design a computer program that spoofed, which was bad. But the other thing that really killed him too in the criminal case was that he had gone into the CFTC in these earlier matters, pre-Dodd-Frank, mind you, before spoofing was, in terms of spoofing, actually illegal, and had essentially admitted to all the conduct. So when his criminal trial came around, and the CFTC is a civil authority here in the U.S., you know, he was sort of doomed to the fact that he had essentially admitted to all the wrongdoing. You know, so it is, the Kosha case is indeed interesting with all the various entities, and, you know, someone who is cynical could say it was a little bit unfair that the Department of Justice sort of waited to the end just to pound the guy into the ground.
So really, a defendant can be in jeopardy for multi-prosecutions or multi-legal actions.
And in the U.S., obviously, the first part was civil, so jeopardy didn't necessarily attach, so it did complicate things. And I'm sure when Kosha started, well, I'm not sure, I would imagine when Kosha started this road, when the enforcers started looking at his trading patterns, you know, he did not ever foresee that he would be, you know, facing jail time, and he would be incarcerated for several years and all that. You know, with that said, it does kind of come, you know, a lot of this, if the fact pattern is a little bit ridiculous, you probably ought to take a step back and look at what you're doing. Because if memory serves, in the Kosha case, there were days, you know, his firm, I forget what it was called, you know, they were responsible for, you know, literally like 60 or 70% of the trade volume in certain commodities, even though his firm was like him and like 3 other guys. You know, that looks bad, right? That's just lots of trades bouncing around. It was it was algorithms designed purely to spoof. So, you know, I don't think, well, I think he should have been surprised that he wound up going to jail. I don't think it was a surprise to anybody that his form of trading received scrutiny, and at the end of the day was not, you know, the CFTC did not embrace him and go, wow, that's great what you're doing to create liquidity in the market. You know, they kind of went the other direction.
Before we leave the UK, I mean, what is the situation as far as the FCA is concerned? Are there many live investigations ongoing in the UK, as far as you know?
There are some. I don't think there are huge numbers. They've made public statements saying that they're interested in this, and they've got some new whiz-bang piece of technology which is sort of picking up and analysing all the trades that are going on. So they've put down a marker, and they've obviously done some, and they've said that they want to do more. But it's a valid question that, to my mind at least, they've been, in relative terms to say the US, they've been relatively slow off the mark in relation to all of this, which is a whole other seminar or webinar, frankly.
All right, well then can I turn to Neil, please, to ask about how spoofing has been treated in the EU?
Okay, well, I think it's right to say that perhaps there hasn't been the same level of activity on this side of the Atlantic within the EU as opposed to what we're seeing in the US. Market manipulation is clearly in the sights of the European authorities, and the regulatory framework is in place. EU legislation, just by way of background, is set out in Regulation 596 of 2014, which came into force on the 16th of July 2016. And this established a new common regulatory framework to prevent market abuse. An underlying intention of the legislation, as outlined by the European Parliament, is to strictly regulate spot and derivative markets, given the crossovers that can occur between them. And it's highlighted that manipulative strategies can extend across both spot and derivatives markets. trades in financial instruments, which include commodity derivatives, can be used to manipulate related spot commodity contracts and vice versa. So the legislation is, amongst other things, therefore aimed at prohibiting market manipulation where crossovers occur. Now, in terms of the conduct itself, manipulative conduct, it's defined in Article 12(2)(c) of the regulations, which largely follow the definitions we've heard about so far. And there is some supplemental guidance on what would be considered to be manipulative, with spoofing or layering described as placing order on one side of the book in order to trade on the other side of the order of the book. And once the trade has been completed, the orders which were never intended to be executed are then removed. And we can refer back to the example I gave earlier at the outset, which fits in with the EU regulations and guidance. And I think if we just turn briefly to the energy markets, these come under specific provisions of the EU regulations, which are catchingly titled Regulation on Wholesale Energy Market Integrity and Transparency, or Remit. And that came into force at the end of December 2011. And this provides regulatory framework to combat market manipulation and governs the wholesale energy markets across the EU and UK. Now in the UK, Remit is governed by Ofgem and the FCA, and as we've already heard, the Agency for Cooperation of Energy Regulators, or ACER. Article 5 prohibits market manipulation, and Article 2 provides a definition for market manipulation, again, largely following a well-trodden path. ACER issues guidance on a relatively regular basis. And then in March this year, they issued further guidance on trading behaviours relating to layering and spoofing. And interestingly, indicates that mere intention of a market trader to give signals or positions that artificially affect a price could be considered as attempted market manipulation. But how that will translate in practice remains to be seen. And as far as enforcement of Remit is concerned, there have been a number of cases for fines and for breaches of Remit, but I don't propose to go through them in detail. Rather, just to highlight there is enforcement activity taking place. And I think just looking at the slide, and I think Josh referenced it earlier, Euronext is the largest stock exchange in Europe, operating regulated equity and derivative markets in different countries, as we can see on the slide. The integration of Euronext's regulated markets in Europe has been fostered and accompanied by regulatory harmonization. A single Euronext rulebook governs all trading on all Euronext securities and derivative markets. And spoofing is specifically prohibited by Rule 8104.14, which again broadly follows the definitions we see elsewhere. And as far as investigations into suspected wrongdoing by Euronext are concerned, these are governed by the rulebook in Chapter 9, and can require the cooperation of members in the provision of material and also access to individuals associated with the member organisations. And the rules set out procedural framework for an investigation to take place. And if a rule breach has been identified, liquidated damages up to, I think, €250,000 can be imposed, or compensation for actual damage or higher, if higher, and potential for suspension or termination of membership. But perhaps more importantly, specifically Rule 9402, it requires Euronext to report any alleged violation of possible infringements of national regulations to the relevant authorities in that jurisdiction. Again, something to bear in mind if they are conducting an investigation. Now, I think finally, and unfortunately, when we're talking about Europe, we have to talk about the elephant in the room, unlovingly called Brexit. And as the UK market is, as far as the UK market is concerned, there remains uncertainty as to what the regulatory framework will be. I think there's still discussions over dinner to take place as we speak, but it seems to be indications that it will largely remain the same. Now, whether you consider we're at the dawn of a new era or a new era, it's clear that in order to conduct business within Europe and currently in the UK, the regulations in place will need adherence to. There's reports of banks moving offices or setting up within the Eurozone in order to continue to conduct business in Europe. And despite the limited application of the regulations thus far, firms would be well served to conduct compliance reviews, either internally or through external expert providers, to ensure their trading strategies and policies are compliant. But as we're seeing elsewhere, authorities are taking the issue seriously, and it's perhaps only a matter of time before we see an increase in investigations, certainly within Europe as the market activity increases.
Thank you very much, Neil. Can I just, leading on from that, ask Nate and Barry to help us about how private market operators are involved in spoofing investigations? I mean, talk us how these would proceed. Should we start with Nate? Well, Barry's
Sure.
on. Barry's got his microphone on. I'm going to take advantage of that.
Well, I'll take advantage of my mic by saying, Nate, get your mic off mute, which it isn't. So.
Yeah,
Okay.
you know, the way these, and that's a great segue into this next slide, but you know, spoofing investigations, spoofing prosecutions, they come in a variety of different ways. And, you know, one thing that's been sort of interesting in the, I guess, 5 years where I've been involved in spoofing cases is the changes in certain trade surveillance platforms and, you know, monitoring programs that are certainly have progressed in terms of picking up on spoofs. You know, and when you have that, you wind up having, you know, pick a private entity of whatever, and it doesn't have to be an exchange up. It could just be, you name it. You know, if you're sitting there running even a high-speed trading fund or something, and you see that somebody continuously tries to spoof you, you know, you will report it because it affects market integrity. You know, the same thing too is that, you know, a lot of regulated industries or entities, at least not industry entities in the United States, you know, will, for various reasons, will have essentially reporting requirements. So if they do detect fraud, whether it be, you know, their own people trading inappropriately, or whether they detect, you know, another bank or another trader, they will report it. And there's certainly a little bit of, you know, banking, trading, it's competitive. You know, there's definitely, I think certain institutions that will remain nameless on this call take a great deal of joy in reporting somebody else to the authorities for spoofing. You know, so it's certainly become a lot easier to detect over the last couple of years, and ergo, it is, you know, they're become, like this slide says steps in a typical spoofing investigation. I don't know what a typical spoofing investigation is. I mean, you know, I think it's fair that those are the usual ways, but you know, these things can come to light in lots of different ways. You know, a bunch of the recent prosecutions we've been talking about, not a bunch, but at least a couple, they came across or they came up through other investigations of other financial products that the Department of Justice was looking at. You know, so if the DOJ is looking at, well, I mean, take precious metals is a great one. I mean, the precious metals spoofing investigations and prosecutions, those all came out of the FX investigation. You know, the big international, you know, we had various people calling themselves the cartel on chat rooms and wondering why, you know, people frowned upon that. But, you know, that's where a lot of this comes too. So there are a million different ways these investigations come up. No offense, Josh, I'm not trying to say you missed anything here, but you know, and the other thing I would point out on this slide is, at least in the United States, what we've been seeing in the last year or two is, you know, a lot of this conduct goes straight to the DOJ and then gets filtered down to one of the civil regulators like the CFTC. You know, it seems like for particularly egregious conduct or for conduct that's been found through another criminal investigation, the DOJ has sort of taken more of a lead in the early investigation, you know, where a few years ago you would have seen the CFTC, because they're, at the time, I think they were better suited to handle large amounts of trading data. They would be the ones to flag bad conduct. You know, so if there's maybe a teaching moment out of this, it is that, you know, spoofing, it may seem like something like, what's the big deal? I have a few traders who are just pushing a button real fast, you know, whatever, they do it once in a while. The fact of the matter is, you know, you can't control who's paying attention. You can't control who's decided, you know, one of those same traders may have just completely, you know, had a huge, great windfall trade. Someone's ticked off in the market about it. Yeah, they report you. You know, so these things do come across in a million different ways.
Can I, before you turn your mic off, Nate, just go on really because you were involved in the defense of the only trader who's been acquitted of a spoofing charge in the US. And can you help us with what lessons you have learned from that acquittal?
I'm fairly sure that's why I'm actually here today. So I'm always available to brag about my accomplishments. So I appreciate that. The Flowtron case was, it was after Kosha. It was really essentially the second spoofing case that got prosecuted all the way to trial in the U.S. And it raised a lot of different issues that have come up again. One that that we talked about before was how do you charge spoofing? How do you actually put out the criminal indictment? The papers that charge it. And Flowtron was initially charged with both a conspiracy to commit wire fraud, ergo where the deception was and all that. And the conspiracy would have been between him and other traders. And then he was charged with substantive spoofing counts that would have required that intent to cancel a trade or to put a trade up. Through a variety of pretrial litigation, we knocked out those spoofing counts, which turned out to be a big part of why we were successful, because those counts would have made things much more complicated for a variety of reasons, not the least of which trying to explain spoofing to 12 sort of lay people in a jury was definitely one of the challenges of this entire process. But explaining a conspiracy, that's a lot easier, because a conspiracy is when Josh or Neil and I get together and we decide we're going to do something bad. You have to have a meeting of the minds. Here, we were able to show there was no meeting of the minds because, frankly, just to get outside of all the spoofing stuff, we kind of went, with what an actual trial is all about. We told a story, and the story was all the traders hated each other because they got paid more if someone else got paid less. So we showed that why would you ever work with someone that you can't stand? One of my cross-examinations, I basically held up chats where a bunch of the traders were talking about what a nasty human being Flowtron was. So that's how, so I guess another teaching lesson here, if you're ever defending one of these, is pay attention to what the charges actually are. Don't get caught up in the spoofing. The other thing that we I think were successful in was just the victims in this case, in the Flowtron case, where it was Citadel was a victim. A bunch of high-speed trading firms were victims. So in front of a jury, the idea that Citadel, a company that makes billions of dollars, their CEO is always in the New York Times for buying the biggest apartment in New York City and all that. The idea that a guy named Andre Flowtron could be sitting in Zurich, hitting a button and really just, really victimizing Citadel, it seemed a little far-fetched. And that's the problem with all these spoofing cases. Sasha, as I'm sure to win a trial, you need a criminal trial. The government has to show victims that have been harmed. Here it's really hard.
Victims, I think, don't you? They've got to be sympathetic victims rather than the type you've been describing, which I think.
Yeah, when you have a 12-person jury of working class, very smart, but working class people in Connecticut, and they're listening to how a billionaire, was possibly fleeced out of 20 or 30 cents on a trade. It's really very hard. They start wondering, why are we here?
Can I just ask Esme to come in on this? Because Emre, you were one of the defense experts in Flowtron, and I just wondered what were some of the ways that you as an expert attacked the state case, the government case?
Sure, thank you, Sasha. Yes, I was one of the economists testifying in the Flowtron case, but I'm also one of the economists who worked on the Title VII of the Dodd-Frank Act, which Josh mentioned, where the spoofing provisions reside. So, I tend to think about the questions of how these regulations are best structured and how it can be improved. And from that perspective, the float run case was a good opportunity to actually display all the weaknesses in those theories behind the spoofing provisions. First of all, after now testifying a couple times in these cases and doing more investigations with other financial institutions, I noticed that what the cancellation in a spoofing means is often misunderstood by most people. I mean, we're not talking about broken orders or fails to deliver after an actual trade is made. We're talking about orders that are placed properly and canceled properly, just like the vast majority, more than 90% of all orders are in the marketplace these days. So the government's argument about these orders were not intended to be filled, so they are deceptive or they are fake, is very nebulous. A properly placed limit order is no more fake than any other canceled order, unless perhaps, as in the case of Kosha that Nate and Josh mentioned before, the time that these orders are displayed are extremely short, such that there's no realistic chance that the order will be hit. So this brings in this, surprising dichotomy between algorithms versus manual human traders in these markets. It's very surprising to see, Nate just mentioned about the billionaire Citadel owner being the victim in spoofing. It also relates to this whole theory about how the price is supposedly manipulated by spoofing. Algos actually historically started by a desire to break down large orders so they don't impact the price, right? So essentially it's coming from, showing your actual intent on order in a different way than it actually is. And now algorithms turned into high frequency trading. And what the high frequency traders do is basically look at the overall order flow and then act very quickly to essentially front run that order flow and make an extra cent. So it's those guys who are supposedly deceived by somebody who may be spoofing.
Sorry, do finish. I didn't want to interrupt you.
Sure. And also it's also difficult to understand how a computer program, which is designed to take an input and then process it in accordance with its programming, can be tricked. I mean, these programs are designed to accomplish certain things based on the order flow, and they constantly get revised based on, what some people call machine learning to adapt to different circumstances. So, the theory that manual traders are deceiving algorithms is a weak one, just like the billionaire is being fleeced by a manual trader sitting somewhere outside the US.
One thing, Sasha, one thing that Emory did that was incredibly compelling during the trial itself was he would take, the government would show snippets of trades that had the alleged spoofing in it. Emory would simply put a minute on each side, and you would be able to see that the behavior actually did make sense, and the behavior was counter to someone wanting to cancel an order, and it was actually trying to simply make trades. So, I mean, that was when Emory came up with those longer segments, and by longer, I am talking 30 seconds on each side. It was incredibly compelling to destroy the credibility of these supposed spoofs.
I mean, what this is telling me, what Emory is telling me really is that the difficulty in proving spoofing, if you are on the prosecution side, because there are so many legitimate explanations for activity which is identical to spoofing in many ways. Emory, is that what you were saying in effect?
Absolutely. There are two things. One is what is essentially picked by in many of these cases as alleged spoofing is very similar to how market makers trade in these markets. And by market maker, we don't mean designated market makers anymore. Whoever has the interest to place limit orders and participate in the markets can be making markets these days. And their activity is very difficult to discern from the selected activities by the government in many of these cases that went to trial. So in a way, you can call that casually as cherry-picked allegations of manipulative trading. The other element is if you try to discern any harm on these algorithms or anybody else who are trading contemporaneously, it's very difficult to see a systematic price impact. Many of the times what is alleged to be spoofing doesn't change the price in a way, or at least it's impossible to, it's not possible to statistically demonstrate that the price was actually moving in the manner that was alleged. So,
so we've looked really at the strengths or the armory that you have and many people will have to attack a prosecution case. Can I ask you all now if you've got any assistance as to what difficulties defendants face when they are charged with spoofing? We know from MRA, we know how to attack the prosecution case, but as a defendant, where are you weak? Does anybody want to come in on that?
Well, I'll get the ball rolling, I suppose. Nate sort of already alluded to some things. I mean, if it's very difficult just on data, and these are data-driven prosecutions or investigations, those arguments can be somewhat undercut using the Forex example where they called themselves the cartel, but for stupid things that people put in emails, chats, and the rest of it that come back to haunt them later. So I would say that can often be a difficulty here. People certainly need to be cautious about what they sort of write down.
Still,
here's one unique challenge in the spoofing case. When you're trying to convince a government prosecutor or someone at the CFTC, or a juror for that matter, that these people did nothing wrong, you're often taking an individual who is relatively very, very wealthy, very successful. There's a stigma attached to traders being maybe not the most honest people in the world. I don't think that's fair, but it is something you do see. And, you start off with certain preconceived notions that make all these things a little more difficult. For example, in our Flowtron case, the government continuously referred to Mr. Flowtron as a Swiss banker, again and again, a Swiss banker. Was it accurate? Yeah, in some ways, but was the reason they did it to make to make sure the jury didn't feel, akin to him? Absolutely. And I think that happens in most, most of us don't, when we're at the supermarket, run into high-speed traders or other traders, et cetera.
Now, we've talked about how most spoofing cases involve the same pattern. So a large fake order on one side of the market and a smaller real order on the other side. And then the larger one is then cancelled. The relevant statutes cover a much broader scope of conduct. And what I want to know really from you is what are the other trading activities that have been prosecuted under the umbrella of spoofing?
Sure. Well, just being mindful of time, I'll just go through these very quickly.
Yeah.
But so the first one is this vacuuming theory. And so as Neil described at the outset, the traditional spoofing case is big order on one side of the order book, real order, a smaller real order on the other side of the order book, and the fake orders are meant to push the market into the small orders. And that's, a number of cases have been brought along that theory. in this vacuuming case that the CFTC brought last year against a trading firm called Hard 8 Futures, they were alleging spoof orders on the same side as the quote unquote real orders. And essentially what they were saying is that the fake orders were used to push up the market, then they were pulled quickly to create a vacuum on one side of the order book, with the result that the market then dropped down into the real order. So this is just notable because, just when everyone thought that they knew what spoofing was, here comes the CFTC, which is kind of a totally new theory. And Hard 8 agreed to just settle the case through an administrative action. So we don't know a lot about what exactly the trade data was, but and there hasn't been a case since. This was in 2019, but it's a notable case for the novelty of the theory. And another thing, I'll just point out is the Lek case was interesting because they were alleging, so it was a Ukrainian firm, a trading firm, and acting together with a US-based brokerage. And what the SEC was alleging was that the Ukrainian firm was placing orders for stocks on the New York Stock Exchange, I believe, not to spoof in the stock market, but to affect related options on those stocks. So it was one of the cross-market manipulation schemes that Neil described earlier. And this was the first time that a case like this was being brought, and it wasn't titled as spoofing. The SEC referred to it as layering, but it was essentially the same type of conduct. And so that was quite interesting. The Smith case we already discussed. It's the RICO action. Again, an extremely aggressive prosecution theory that we'll see how that plays out. And the SEC versus Chen case, just quickly, that was interesting because it involved, I think it was 18 or 20 traders are being sued, and actually a few of them are being criminally prosecuted as well. But this is a case pending in Boston, and it involved multiple different trading accounts, some through kind of nominee entities. And the SEC's theory is that there were kind of winner accounts and loser accounts, whereas the loser accounts would put in big fake spoof orders to benefit other orders that were put in place by the winning accounts. And obviously, the theory underlying this case is that this was being done to complicate matters for law enforcement, and kind of hide exactly what was being done. So this is another very interesting case that is currently kind of winding its way through the courts, and we'll see what happens there. But I think the takeaway from this slide is just that spoofing is a fairly broad topic that can encompass a variety of different trading practices, and I think the U.S. government at least is pushing that boundary further and further to create kind of new crimes where potentially previously people didn't really identify them as such. So these are very interesting cases that obviously we could talk about them a lot more in detail, but just suggest anyone can kind of look them up and see what the details are, but they're quite interesting.
I mean, 2020 has been a big year for spoofing, particularly with the JP Morgan case. Can I ask Nate what we can expect really now there's a change of administration, or there will be on the 20th of January under President Biden, President-elect Biden? Nate?
I think, the interesting thing is there are enough of these cases in the queue that a lot of it is sort of largely irrelevant to the change. Assuming we'll have a new attorney general. With that said, it will be interesting, as Josh pointed out, whether like the use of the RICO statute, something that was designed to go after the organized crime in the U.S. It'll be interesting to see if that continues, because that is aggressive, to say the least. It is. I think some of us were a little surprised when we saw that, and I would wonder what when a jury sees two traders, on the at the defense table, and then here's the, they're being tried in the same way they went after John Gotti, how that will actually work. The one thing I do, Josh hit on this, I do think you're going to see increasingly complicated spoofing prosecutions. I think, I think you're going to see it in different products. So most of these have been in precious metals so far. I think it's going to branch out. I can tell you, I would be very surprised if we didn't see some spoofing cases involving, different tenors of a product being traded, like a 1-year product X versus a 10-year. I've had a lot of discussions about whether that's actually even feasible with people, and apparently some people do think that's a great way to spoof. Not that this today is a how to spoof lecture. Like I don't recommend trying it, but that's something that I think we'll see more of. The one thing that's interesting about all financial crime is any time you kind of think you've seen it all, you haven't. Someone always comes up with something new and interesting and that works for a while.
Yeah. It's organic, really, isn't it? That's the point.
Yeah, and with all the volatility in the markets that was created by the pandemic, I'm sure once the authorities, regulators, whoever start, or the plaintiffs' lawyers for that matter, start going through all that data, God knows what they're going to find there. So, I think it's I don't think we're going to see spoofing go away by any stretch of the imagination. It's one of these things that's probably a little bit Trump-proof, maybe, for lack of a better term. I don't.
Can I wrap up by asking Barry, really, what are some of the best practices for traders and trading firms to prepare themselves for regulatory scrutiny of their trading? Barry, can we have your microphone on, please?
Yes, happy to chip in. Well, first of all, I think it's important to understand what your traders are up to if you're a firm. So, what sort of trading patterns, what sort of trades are being put up, what trading patterns have you got? Likewise, for individuals, understand, what impact you're having, what are you actually doing? The Sorrell case, which is an extreme case, was an extremely clever young guy trading from his bedroom, managed to crash the US stock market. So, I think going back to this point that Nate made, if you're sort of having a disproportionate impact, you're going to attract scrutiny. Be mindful of what you're actually doing. If you're a firm, understand what it is that your traders are doing. I think if you've got trading strategies and you are sort of wondering whether or not these sorts of things would be impacted by the spoofing, the tapestry of regulation that's out there, then it would be sensible to run them by somebody and see what they say, to give you a bit of advice so that you can understand whether what you're doing is something which is going to be problematic or not. Actually do that. I think, as the point that I made earlier about the sort of written communications, just be mindful. I'm often struck when I look at some of the things which people have either said or written, which then stick around for a long time, and then people use to interpret particular alleged misconduct. That sometimes things that are written are extremely, first of all, they can often be completely wrong, but can create all sorts of curiosity and interest on the part of investigators, sending them down some sort of lengthy investigation only to find that actually, whatever was being described wasn't the case or whatever. So, just be cautious about the sorts of things that have been written down. Mm-hmm. And with that in mind, to the extent that there are trading strategies, bear in mind that the regulators will look back years at some of this conduct. I know there's statutes of limitations in the US, but they can go back some considerable time. They're not averse to using case theories that seek to extend them even beyond the usual. But if you have a trading strategy that you've thought about, you've considered in the context of regulations, then probably not a bad idea to document, or a good idea rather, I should say, to document what that strategy is, what you thought at the time, so that rather than looking at things 10 years or 6 years later and some unhelpful documentation from which people tried to pass what actually went on, some documentation which actually helps them understand that what was going on at the time was perfectly lawful, and that they there's nothing to see here to move on and do something else.
Barry, just arising out of this point, if I can chip in just with a question we've had from James Burgess, what he has asked is, you mentioned that the cartel chat room really helped build prosecution cases in the FX investigations. What other examples are there of the communications between traders that have really assisted the prosecution case? So that arises really about the care you're saying should be taken by people speaking in chat rooms and live chats and the like. Are you able to say what other examples come to mind, or anybody?
I can. That would be every single case I've worked on for the past 10 years.
Okay. Okay. So basically it's loose lips, traders and submitters who don't imagine that their conversations are going to be scrutinized or looked at by third parties.
Yeah, Mr. Burgess, there's a book called The Spider Network, which is about the LIBOR case, which is the guy who wrote it. And I don't get money for selling his book. I could care less, but it's actually a pretty fantastic read, and it shows how the entire LIBOR prosecution case was all made up of little chats. I mean, that's a great example if you just want to read something quickly. But again, I mean, I think everyone on this call, if it weren't for stupid chats, I wouldn't have a new kitchen. Yeah.
Okay. We have another question, if I may, just from Gregory Durston, who says that in the Abatista case, the defendant argued unavailingly that they were testing market liquidity with their large and quickly withdrawn orders. Is there any plausible reason other than manipulation that a trader might place such an order while placing a smaller order on the other side? So this is a hypothetical question. The pattern we see with what's been described as classic spoofing, is there a legitimate reason for that pattern of behavior, of trading behavior? Anybody want to come back with an answer to Gregory?
Sure, I can take that. I mean, yeah. I think there definitely are, and I think everyone on this panel will agree with me. I mean, I think one of the things about trading that makes prosecuting these cases difficult is, you can't control what happens to your order when you put it out on the market. So a lot, and everyone is testing to see what the other counterparties who are out there in the world, how they react to certain orders. So, I think if in the Abatista case, if that was his defense, I could see a plausible explanation being, well, I didn't know what was happening in the market, so I decided to dip my toe in, put an order out there, and see how the market reacted, and then adjust the rest of my trading accordingly. So, there's nothing inherently illegal about putting an order on one side of the market and then a large order on the other side of the market. So,
isn't that what hedging is anyway?
Exactly. So, I think that I think is the overall kind of conceptual difficulty with these spoofing cases, is that drawing the line between legal and illegal conduct is very difficult. And as I think we've alluded to, a lot of it just comes down to the intent. And going back to the previous question, I think that the difference between criminal spoofing cases and civil spoofing cases oftentimes is a bad chat or a bad series of emails or a bad recording that, kind of give the prosecution ammunition to go after, to make it a criminal case. Can
I come to what's going to have to be the last question, and it's specifically directed at Emre. So Emre, please, if, as Emre says, spoofing can't be shown to impact the price, why does the spoofer spoof?
Well, if it is spoofing as alleged, you might think that the spoofer indeed was thinking he's going to affect the prices and that he did it with that intention, but that doesn't mean that he was successful in doing it, especially in a repeated situation. If you look at the overall evidence, you'll generally not be able to find the price impact. But it's not impossible. So I didn't say it as a generality. I said it in the cases that I've analyzed that came to trial so far. You haven't seen a price impact put forward or demonstrated by the government.
Okay.
And Amory, wouldn't it also be true that, you know, traders have order books, they have orders to fill, they have lots of reasons they need to fill orders. It doesn't necessarily, they're not trying to squeeze every, you know, little bit of profit out of trades at all the times.
That is true. And that goes to the previous question as well. Good point.
Thank you.
Can you tell Emery and I have spent an ungodly amount of time together?
Thank you very much, Emma. I think we're going to have to wrap it up now. So can I say a big thank you to Nate and Barry, Emre, Josh, and Neil, who have all enlightened me, certainly, in the developments of spoofing. And thank everybody who sent in the questions and everybody who has participated in this webinar. So thank you very much indeed.